Hello everyone, and welcome to the November 2022 episode of My PIP Monthly. As always, my name is Amber Rouse Holloway, and I'm a partner here at our Troy office. Our November 2022 topics include, of course, the case law discussion. I'll be discussing some somewhat older unpublished opinions. First, we'll start off with Alice Jenkins v. Suburban Mobility Authority for Regional Transportation, and then we will end up with Michele v. MI PIP, and this one will eventually be published if it is not already published. And then we will move on to trending topics in PIP litigation, and we will discuss the Michigan Public Health Code and unethical business practices, and essentially how to file or prepare motions for summary dispositions based on the Michigan Public Health Code and those unethical business practices. Right. Alice Jenkins v. Suburban Mobility Authority for Regional Transportation, and this one is an unpublished opinion that was issued January 13, 2022. Now, this case surrounds issues of arbitration and essentially whether or not a plaintiff can arbitrate claims from a provider to which the plaintiff has already assigned her benefits. So a plaintiff gets into a car accident and treats with all these providers. Some of the providers she has signed assignment for benefits and some she hasn't. But essentially the outcome of this case was that plaintiff has no right to arbitrate those claims which she has assigned her right away to those providers because they're no longer hers. And I have some case law here that says arbitration is a matter of contract, essentially, and a lot of issues surrounding arbitration and the arbitration parameters are discussed in these two seminal arbitration case law. Along with the preceding case law in the last slide, the issues of arbitration and arbitration parameters are described in MCR 3.602, and that's where you first want to go to figure out how arbitration rules should be done. It's important to note also that when an arbitration happens in a case, that although it's normally dismissed from the court's docket and put into arbitration, the courts typically, in this order for dismissal, retain jurisdiction to assist with arbitration matters. So even if it's been dismissed, you would cite MCR 3.602 as a seminal rule to enforce the rules of arbitration. We also have the Uniform Arbitration Act, which is MCL 1681, and that also governs arbitration rules. But essentially, like I said previously, this case centers around the fact that a plaintiff cannot arbitrate claims related to the treatment provided by medical providers that have assignments because those claims are no longer hers to maintain. So it's really important that this case exists for us to rely upon, because you do have situations that are in litigation today, or claims that are in litigation today, where the claimants or plaintiffs try to beef up their claims with these providers, and then you come to find out that these providers have assignments. And if a case does get to the point of arbitration, it's important to note that in your arbitration agreement prior to dismissing the case and removing it from the court's docket. Next up, we have the case of Michele v. Michigan Automobile Insurance Placement Facility, or the MAIPF. And this is the first published opinion of its kind in Michigan to consider the issue of discoverability of retained experts' financial information. Here, the Court of Appeals essentially stated that this is going to be a case-by-case determination, and it's depending on a balancing test of interest, including privacy interests of the expert and the seeking party's need for the information. So essentially, it can't be a situation where they're just trying to get this information for the hell of it, or just to make a party look bad. It's a case-by-case determination, and it must be important to the case at hand to seek an expert's financial information. But by way of background, I did want to go into a very quick background on this one. In the underlying trial court, plaintiff issued a subpoena to Ability Assessments, and that is the IME provider, seeking the financial records as well as the number of IMEs performed by Dr. Mary Nizer at Ability Assessments. They requested this information for the prior 4 years, and they also requested the number of patient examinations conducted by Dr. Nizer at Ability Assessments over the last 4 years. Here, defendant Citizens Insurance Company of the Midwest moved to quash the subpoena, arguing that MCL 2.302B4A plaintiff could not seek the requested information by subpoena without first seeking leave of the trial court that records the number of her patients, and the IME examinations were irrelevant to the actual case at issue. Citizens argued that the subpoena from plaintiff was merely sought to harass, embarrass, and dissuade participation in the litigation process and would impose an undue burden on Dr. Nizer. The trial court did deny Citizens' motion to quash, as well as the motion for reconsideration, and Dr. Nizer and Ability Assessments, as a non-party appellants, sought leave to appeal in the Michigan Court of Appeals, which was granted. Now, the majority of the Court of Appeals first analyzed the applicability of MCR 2.302B4, which limits the means of discovery about or from an expert witness, but does provide that a court order may be issued for further discovery by other means. The majority noted that this court rule only applies to facts known or opinions held by experts that were acquired or developed in anticipation of litigation, not any and all information possessed by an expert. The court cited the Linbaugh v. Sheraton Mish Corporation case for the reasoning that the information acquired by an expert as a factual witness or as a result or consequence of his or her normal business activities or duties fall outside of the scope of the relevant court rule here, which is MCR 2.302B4. The court noted that plaintiffs sought records kept in the ordinary course of business and not facts or opinions acquired or developed in anticipation of litigation of trial. And the majority concluded that by its plain language that this court rule did not apply. The majority then went on to consider whether the discovery subpoena sought information beyond the scope of discovery as defined in MCR 2.302B1, but ultimately the majority found that the information sought was relevant and it had a bearing on Dr. Nizer's credibility, and information that bears on a witness's credibility or bias is never irrelevant. Considering the appellant's contention that the subpoena should have been quashed as unreasonable or oppressive, the majority concluded that the trial court's analysis in that regard was inadequate, and they essentially opined that the plain language of MCR 2.302B1 clearly obligates that the trial court balance the burden of the proposed discovery against the value of the proposed discovery, and that is what was done here. Moving on to trending topics in PIP litigation. So again, I wanted to discuss the Michigan Public Health Code and how it bans unethical business practices and unprofessional conduct such as fraud and self-referral. Now, this situation comes up in litigation when for example, what made me think of it for this specific MI PIP Monthly was a case where I have these medical records and I find out that a plaintiff has been prescribed durable medical equipment. Now, we dig a little deeper and we find out that the alleged prescriber did not actually prescribe or testified under oath that they did not actually prescribe this equipment. And then that was done during that provider's deposition. Not the durable medical equipment provider, but the referring provider's deposition. So in that deposition, the provider testified that he did not recall, and he would not have. Not only did he not recall, but he plainly stated he did not. And then he goes, and no one in his office prescribed the durable medical equipment also. So because of that, he alleged fraud. His signature was actually used to prescribe these fraudulent prescriptions and provide this fraudulent equipment that he did not believe the claimant or plaintiff required, or did not require from him specifically. Now, MCL 333-16221 D3I handles fraud or deceit in obtaining or attempting to obtain a third-party reimbursement. Now, this slide goes into unprofessional conduct and what it includes: misrepresentation. A provider must have a license. Now, here in my specific case that I just talked about, not only was there misrepresentation by the durable medical equipment provider, there was also fraud committed as to the alleged prescribing provider. Now, we all know that under the No Fault Act, the only benefits that are required to be paid are benefits that have been incurred and are reasonably necessary for the patient's care and recovery. In fact, it's the plaintiff's burden to demonstrate that these reasonably necessary benefits were incurred. Now, in order for a benefit to have been incurred and reasonably necessary, treatment must be lawfully rendered to an injured person covered by a PIP policy. And that's MCL 500-3151. And to top it off, just a little icing on the cake, Michigan's common law wrongful conduct rule provides that a person cannot maintain an action if, in order to establish his cause of action, he must rely in whole or in part on illegal or immoral act or transaction to which he is a party. And that comes in when for example, in my case, when the durable medical equipment provider is the plaintiff. So they are seeking payment for this equipment that they've provided to a claimant. However, that equipment was fraudulently prescribed. So in that case, you can use the Michigan wrongful conduct rule as a defense. Now, if you have all of that perfect storm of information or perfect storm of facts, then you can file a motion for summary disposition based on those rules and argue that plaintiff's complaint may be barred based on the application of common law and statutory versions of the wrongful conduct rule. And you would argue that treatment was neither incurred nor reasonably necessary and unlawful. And that is all I have for you guys today. Again, my name is Amber Rouse Holloway, and I always welcome any questions and concerns. And I would like to thank those who are listening who have sent questions recently. I've been getting a lot of them, and again, I always welcome them. Or if you guys have any ideas for future topics, especially in the portion of the trending topics in PIP litigation, I always welcome those as well. Thank you.